Discharging board members. This can be a very contentious part of the life of a corporation. At some point, maybe you need to get rid of a board member. You want to make sure that the company's acting efficiently. Maybe one of your board members is being a problem. Today, we're going to be looking at what does it look like to try to get rid of a board member. I'm Shawn McBride. I'm a practicing business lawyer. I work with a lot of business owners on a number of issues, including dealing with issues with our board of directors and potentially discharging board members. So today we're going to jump into that on today's show, get into some details and talk about what you need to know. Obviously, you may need to consult with an attorney. This is not legal advice. This is just general education about what's happening out there. So let's go into it. Boards of directors are generally selected by the stockholders. So if you go to your corporate documents and you go to your applicable corporate statute, it might be a Delaware General Corporation Code, Texas Business Organizations Code, might be a number of different statutes depending on what state your corporation is formed in. So that's generally what's going to matter is your state of formation. So not necessarily where you're operating, not necessarily where your offices are, but where you're formed at. And many companies are formed in states like Delaware, Wyoming, or others. There's cases out there where companies are formed in one state and operating in another. So to the extent there's any disagreement, in general, the most applicable law is going to be the law of the state that you're formed in. So that's what's going to be determining these decisions. And if you work through that corporate law and then your certificate of incorporation and your bylaws, what you're going to find in almost every case is that the board is selected by the shareholders. Now, you may have a shareholders agreement as well. So many times that's layered on there. You have both the state law and the corporate documents, and then somebody has signed a shareholders agreement. In general, that shareholders agreement, assuming it's enforceable, is also going to play into this analysis because it may talk about who gets board seats, how voting is done for board seats, and really in a lockup type situation where certain seats go to certain people, other seats go to other people, or the votes are split. Could be a lot of different scenarios. All of this to say is you've got to do some corporate archaeology to figure out how directors got onto the board, and then is there a removal tool? Sometimes a percentage of your sitting board can remove a director. Otherwise, it's generally going to be off to the shareholders. And this is either going to require a written consent if your bylaws so provide and your state law is supportive of that. You may be able to do this in writing to remove or reset your board without the person that you want to discharge. Or, in some cases, you may have to go to an actual shareholders meeting. You may have to bring the shareholders together and do a vote. Now, you can use things like proxies. A proxy is a way of having one person vote for another, so that is a possibility here. But at some point, you may have to go to an actual vote of shareholders to say, does this person stay or do they go? And so that's something you want to be looking at, and you need to work through your documents. Now, with discharging a director comes the potential for claims by that director for wrongful termination or discharge. But if you follow the corporation law and you don't violate a shareholders agreement, those claims may be without merit. You may be able to very well defend those. But what's key is you've got to dot your I's and cross the T's. The order of operations here is very important, particularly if you have interplay between the board and the officers. There's some case law out there very interesting where a board went to terminate an officer, but they didn't properly call the meeting. The officer actually stayed in power and called a shareholders meeting, and the court went back and looked at it and said, well, that board meeting was not a valid board meeting, and because it wasn't a valid board meeting, you didn't remove the CEO. The CEO called the meeting, and therefore the meeting was validly called, and then the CEO ousted the board, right? So these are the types of things that can happen if you don't dot your I's and cross your T's. So if you're getting into this situation, something you want to pay careful attention to, make sure you get everything right. If you have questions or comments that are general in nature, I welcome you to drop them below. We get a lot of great suggestions for videos in the comments, so we appreciate that. We look forward to reading those comments, but don't put anything confidential there because other people might see it. Hope you subscribe to the channel, and I'll be back with you with another video very soon.